Welcome to this explainer on a genuinely fascinating intellectual property dispute. Today, we're diving into GR No. 214148, Phillips Seafood Philippines Corporation versus Tuna Processors, Inc. This is an absolutely definitive case in commercial law when it comes to patent infringement, specifically looking at the precise methods used in commercial food technology. Let's get right into it.
We're going to anchor our analysis today with the Supreme Court's opening line, which states, "The importance of patents as a tool for national development and economic advancement cannot be overemphasized." It perfectly highlights that really delicate balance we have in commercial law between granting market exclusivity to an inventor and drawing the exact boundaries of a patent claim so we don't accidentally stifle future innovation.
To meticulously dissect this case, we'll be following a strict case digest format. We're going to cover the facts, the arguments of both the petitioner and the respondent, the issues, the ruling, and finally, the rationale.
Let's get right into part one, the facts. The Great Tuna Smoking Dispute.
Okay, let's meet the players. We've got our petitioner, Phillips Seafood, and our respondent, TPI, who is the successor in interest for patent I31138. Now, to really grasp this conflict, we need to detail the precise technical steps of the patented process. The independent claim involves 4 very specific steps. First, burning a smoking material at 250 to 400 degrees Celsius. Second, passing that smoke through a filter to remove mainly tar. Third, cooling the filtered smoke in a cooling unit to between 0 and 5 degrees Celsius. And fourth, smoking the tuna meat by exposing it to this extra low temperature smoke. The inventive step here is incredibly specific, right? It's all about exposing that tuna to extra low temperature filtered smoke to get maximum sterilizing and preservative effects.
Now look at this side-by-side comparison of the two methods. A clear mechanical divergence emerges right away. While Yamaoka's patented process specifically pre-cools the smoke in a cooling unit down to between 0 and 5 degrees Celsius, Phillips' process does something entirely different. They filter the smoke to remove tar, odor, and impurities, sure, but then they let it cool to ambient temperature in a plastic bladder. They inject that ambient smoke directly into the meat, and only then is the injected tuna put into a refrigeration unit set to -3 degrees Celsius. So structurally, that mechanical divergence is plain as day.
Moving on to part 2, the arguments of the petitioner, Phillips Seafood Philippines Corporation. So Phillips firmly denied infringing patent I31138. Their primary argument? It rests on the absolute, literal absence of a cooling unit in their process. They insist that because they inject ambient temperature smoke directly into the meat, they completely bypass the patent's strict requirement for extra-low temperature pre-cooled smoke. Plus, Phillips threw in an invalidity defense for good measure. They argued the patented process actually lacked an inventive step entirely, claiming that all elements of Claim 1 already formed part of the prior art.
Next up, part 3, the arguments of the respondent, Tuna Processors, Inc.
TPI went with a dual-pronged approach here. First, they argued literal infringement, insisting that the claims of the patent could be read directly, literally, from Phillips' process. But they didn't stop there. TPI argued that even if it wasn't literal infringement, Phillips was still liable under the doctrine of equivalence. Basically, TPI claimed the combination of steps in Phillips' process was substantially similar. They heavily focus on the filtration step, arguing that the patent's phrasing, removing mainly tar, naturally encompasses removing other impurities like odor as well.
This brings us to part 4, the issues, the core legal questions at play. The court essentially had to untangle 2 definitive legal questions here. Number 1, whether the Court of Appeals' interpretation of the phrase "to remove mainly tar therefrom" in Claim 1 is proper. And number 2, whether Phillips' process actually infringes patent I31138.
Which leads us right into part 5, the ruling, the Supreme Court's decision. The court delivered a really definitive ruling in favor of the petitioner. The petition for review on certiorari was granted, and the court officially determined that Phillips' tuna smoking process did not infringe on patent I31138. But, as we know with commercial law, the why is just as important as the what. We need to examine the reasoning.
So let's unpack part 6, the rationale, the legal principles and doctrines applied. Addressing that first issue, the court actually agreed with the appellate court's broader interpretation of the filtering phrase. The phrase "to remove mainly tar therefrom" equates to "remove mostly tar." The word mainly is just not equivalent to only. It simply states the primary purpose of the filtration process, meaning it doesn't preclude the filtration of other things, like odor. But, and this is a big but, The court clarified that this interpretation alone was totally insufficient to support an infringement claim.
This brings us to the tests for patent infringement, starting with the literal infringement test. Under this test, courts look closely at the elements of the invention as expressed in the actual literal words of the claims. Applying this, the court found no literal infringement. Why? Because Phillips completely lacked the crucial step of pre-cooling the smoke in a cooling unit to between 0 and 5 degrees Celsius before exposing the tuna to it. That exact identity just didn't exist.
All right, since literal infringement failed, the court shifted gears to the doctrine of equivalence test. This doctrine is super important because it recognizes that infringers might try to make minor modifications just to evade literal infringement. Under this test, the court evaluates if the competing process appropriates the prior invention by performing substantially the same function in substantially the same way to achieve substantially the same result.
Now, a key measure of equivalency under that doctrine is the insubstantial difference test. It looks at whether the changes adopted by the alleged infringer are just insubstantial substitutes. Basically, if a person skilled in the art knows the modification is a mere substitute, it's an insubstantial difference, and infringement still occurs.
To really nail down this equivalency, the court utilized the triple identity test. You might also know this as the function, means, and result test. It evaluates 3 specific criteria: the function, the means, and the result. For infringement to occur here, all 3 of those must be substantially the same. So applying this to the Phillips process, well, while the function and the result were similar, because they both aimed to cure tuna, Phillips ultimately failed the test because the means were not substantially the same. The Supreme Court noted that injecting ambient temperature smoke significantly alters the rate of chemical reactions between the smoke compounds and the proteins in the meat. Also, TPI failed to prove that simultaneous cooling of the meat in ambient smoke yields the identical maximum sterilizing effects as Yamaoka's strictly pre-cooled smoke method.
Finally, the court invoked the all elements test. This is a linguistic framework that requires the doctrine of equivalence to be applied to the individual elements of the claim, not to the invention as a whole. This is absolutely vital. It ensures the public notice function of the patent-specific claims is heavily protected, preventing courts from improperly enlarging the scope of a patent beyond what the inventor originally claimed.
When applying the all elements test, TPI just failed to discharge their burden of proof. Phillips' process outright lacked equivalent mechanisms for 2 of the 4 essential patented elements. First, they didn't cool the smoke in a cooling unit, and second, they didn't expose the tuna to smoke that was already cooled to between 0 and 5 degrees. The court firmly established here that simultaneous cooling in a refrigerator is just not legally equivalent to utilizing pre-cooled smoke.
We'll leave you with this final thought to consider. How does the strict application of the all elements test establish boundaries that protect both the original inventor and future technological pioneers? By demanding exactness in patent claims, commercial law ensures that while an inventor's specific process is completely protected, the door always remains open for competitors to genuinely innovate through substantially different means. Thanks for tuning into this explainer. Keep learning and stay engaged.